Hi everyone and welcome to another Paddocks video tutorial. Living in sectional title schemes creates an intensified community that often results in conflict. In this video, I will address 6 of the most commonly asked questions regarding bodies corporate and litigation. So what is the legal nature of a body corporate? The Act states that when any person other than the developer becomes an owner of a unit in the sectional title scheme, a body corporate is formed by the operation of the Sectional Titles Act. Body corporate is a juristic person which has perpetual succession. So who's cited as a party in the legal proceedings? It's the body corporate who is cited, because the body corporate is capable of suing and being sued in its own name. In section 36, subsection 3 of the Act sets the template for the official name of every sectional title body corporate. The name and number of the scheme can also be found on the first page of the sectional plan, which is registered at the Deeds Registry's office. Although the trustees of the body corporate are responsible for the control of common property for the benefit of all owners, it's the body corporate who is cited as the party to the litigation proceedings. So in what circumstances should a body corporate litigate? Bodies corporate have capacity to sue and be sued regarding the following matters. 1. Any contract it makes. 2. Any damage to the common property. 3. Any matter concerning the land or the buildings for which it is responsible or for which the owners are jointly liable. 4. Any matter arising out of the exercise of any of its powers or the performance or non-performance of any of its duties under the Act or the rules. And 5. Any claim against the developer. So how is litigation authorized by the body corporate? An ordinary resolution of the body corporate is usually required to authorize litigation, except in the case of litigation against the developer, because this requires a special resolution. The general meeting, by ordinary resolution, is also entitled to give directions or restrictions to the trustees. So in this regard, a direction, for example, would be the instruction to the trustees to initiate legal proceedings, while a restriction would be a limitation of trustee spending above a certain stipulated amount on legal fees without first obtaining the authorization from the body corporate. An example of this occurred in North Global Properties versus Body Corporate of the Sunrise Beach Scheme, where the court found that the legal costs would definitely exceed the trustee's spending limit of 50,000 Rand, and therefore came to the conclusion that the trustees didn't have authority to bind the members of the body corporate without their express mandate to incur such legal expenses. Furthermore, the trustees should include a line item for legal fees in their budget every year. The body corporate could be forced to defend or enforce its rights, and if it does not have money put away in reserves to cover this expense, the trustees would be forced to raise a special levy. Additional instances that require body corporate to approach the court are: 1. To obtain a unanimous resolution, where they cannot do so. 2. To recover arrear levy contributions and special levies. Or 3. To apply for the appointment of an administrator. In all other instances, it is only appropriate to initiate litigation in cases of urgency. Where the dispute is not urgent, the trustees should refer the matter to arbitration, which may be made in order of the High Court. So which court has jurisdiction to hear body corporate matters? The body corporate may institute or defend legal proceedings in the provincial or the local division of the High Court having jurisdiction, and in the magistrate's court, depending on the cause of action or the matter and the amount of money that's being claimed. The body corporate may use a magistrate's court for levy collections, but must use the High Court to obtain a unanimous resolution, also for the appointment of an administrator and for any delictual claim for damages. Only natural persons may institute proceedings in the small claims court. However, a body corporate will have to appear in such a court to defend a civil claim for an amount of money less than 15,000 Rand. So who pays for the legal fees? In terms of Prescribed Management Rule 31, subsection 5, an owner is liable for and must pay all legal costs, including costs between attorney and client, collection commission, expenses and charges incurred by the body corporate in obtaining the recovery of all arrear levies, or any other arrear amounts due and owing by such owner to the body corporate, or in enforcing compliance with these rules, the conduct rules, or the Act. The judge makes the order as to costs and can determine that the cost be paid by any one of the parties or by both of them jointly, or in such shares as the judge may determine. The costs order usually follows the outcome of the proceedings, but it must be noted that the legal fees may be taxed. In simple terms, this means that the body corporate will never recover all the legal fees expended in initiating or defending legal proceedings. I hope you enjoyed this video and will find the information helpful. If you have any queries in this regard, please contact us at consulting@paddocks.co.za. Thanks for watching and goodbye.